skeptical because I thought that I'm teaching for nearly 2 decades. What else they are going to teach me? But after coming here, I'm really surprised that there is so many things to know and to learn and to adopt for myself.
I'm happy to report that, ever since I came back from the TTT in Manila, the number of students has increased. The first set of students which I taught in 2015 after I came back was 4 students. And the next semester, the registration went up to 30 students. That was the maximum limit. And ever since then, it was holding steady between 25 to 30. And the students themselves came back to me and said that this is the first elective subject that they have enjoyed.
I mean, the great value that I've seen of this TTT program is really the networking. They've now developed networks which have been fantastic, and they've been exposed to other environmental law professors within their region, and they're doing amazing things.
What is surprising to me, it is that after the TTT, several of our professors started another group. That is not for the environmental teachers alone, but also for the Environmental Protection Agency, the local people who really go to the polluters to find. I never realized there were so many practical questions that has to be answered. And what chemicals is toxic, why it is toxic, what's the legal basis, how much I should fine. That's also not only benefit those officials, but also benefits the teachers, because that's the real things, the real world. It's amazing. And I think the group is growing.
By focusing on training the trainers, we create the infrastructure to ensure that this growing demand for environmental law knowledge is going to be satisfied. I think this has been probably the biggest success that the Academy has had to date, because they've succeeded in mobilizing professors from all over Asia at a time when there's such a huge demand for improving environmental law, and yet nearly all these universities lack the capacity to be able to teach environmental law because they didn't have people who had the specialized knowledge that the environmental law field requires.
After this ADB TTT program, I told my students, go to an affected area, meet the stakeholders, and find out why exactly is this problem. For example, there was a lake nearby which was being encroached by a lot of illegal occupants. So 2 guys went there and met the residents. They went to the elected representatives of the municipal bodies. They went to the government officials who are responsible for protecting the natural resources. So the moment when they reached the government officials, they got a point that these students are really going to make it a big issue. And therefore, the government immediately acted upon this issue, and they cleared all the encroachments and they built a wall around the lake to protect it permanently. I think this is a small victory as a teacher that I could inspire my students to do such a thing. The change should start from each and every one of us.
Look, it's been inspirational, frankly. I've found myself totally inspired by the commitment, the enthusiasm and the capacity of the people that we've been very fortunate to locate. So we're actually building a bottom-up resource now of environmental law teachers, and to which we're adding all the new people that are coming in through the training, mixing with the more older experienced teachers in their own country, and building a whole base there to carry this work on well into the future, which I think is one of the most exciting things of all, to see that this project has a lifetime, a longevity and a sustainability beyond the actual training.
Thank you very much indeed, Angela, and good morning, good afternoon and good evening to all of us participants and our speakers who are joining us tonight for this very interesting discussion, we hope, on ecocide, a new and proposed environmental crime under the Rome Statute. My name is Matthew Baird, and I am the MC for this evening's event as the team leader for the Asian Development Bank's Developing Environmental Law Champions program. And if I can just sort of set the scene for us in the webinar tonight, the Law and Policy Reform Program is a key component of ADB's vision to alleviate poverty in the region. And since 1995, LPR technical assistance projects have helped develop member countries establishing strong, fair and predictable legal frameworks, develop the capacity of judiciaries and enforcement agents to uphold the rule of law, and create enabling environments for sustainable development. The LPR program is anchored on promoting legal and regulatory reform in developing member countries. It works to build and support legal infrastructure. Those are the rules of the game that will encourage domestic and foreign investors to do business, spur economic activity, raise livable incomes, and ultimately foster growth that is inclusive and sustainable. The Developing Environmental Law Champions Technical Assistance Program is focused on supporting the development of environmental law teaching. And we have also a TA that's focused on environmental law judicial training and capacity development. And this webinar tonight is the final in our series on environmental compliance and enforcement, with the support of the Asian Environment Compliance and Enforcement Network and the Asian Research Institute for Environmental Law. And our last 4 webinars have attracted over 1,000 registrations, and we've had lively discussions on environmental impact assessment, compliance and enforcement, environmental crime, waste crime. And our aim here is to contribute to thought leadership of the ADB in environmental law and as a knowledge institution. So it's with that background, it's a great pleasure to welcome tonight our panelists and also to introduce Damien Eastman, who is an Australian qualified lawyer and is the Deputy General Counsel at the Asian Development Bank. Damien assists and oversees Office of General Counsel's 100-strong legal team in advising and guiding ADB management, ADB's Board of Directors and Board of Governors on all manner of legal issues concerning ADB's internal and external operations. Prior to joining the Asian Development Bank, Damien spent more than 10 years in the legal department at the International Monetary Fund in Washington, DC, and before that in private practice in Sydney and London-based law firms as a commercial litigator. It's with great pleasure that I introduce the Deputy General Counsel of the Asian Development Bank, Damien Eastman. Thank you, Damien.
Thank you very much for that introduction, Matthew. And let me welcome all of you to this webinar on environmental law hosted by ADB's Office of the General Counsel Law Policy and Reform Program. So today we're here to consider the proposal to make ecocide an international crime. It's an idea that's gaining momentum globally. The proposal to make ecocide an international crime would fill a gap in the existing international legal order, where there is currently little to deal with crimes affecting the natural world. Now, as many of you will know here, at present, the International Criminal Legal Order addresses a number of crimes which come within the jurisdiction of the International Criminal Court. These are genocide, war crimes, the crimes of aggression, and crimes against humanity, which in essence are all crimes against individuals or groups of people. Crimes against the natural world don't really fit within these existing categories and thus don't come within the jurisdiction of the ICC, hence this proposal. Now, a recent definition of ecocide was developed by a panel of experts, which includes 2 of our distinguished panelists here today. And under this definition, which I think we're going to put up into text a little later in the webinar, certain acts with a substantial likelihood of severe and widespread or long-term damage to the environment would amount to ecocide and be criminally punishable. And the idea, at least initially, is to catch those most abhorrent and egregious acts that cause widespread or long-term damage to the environment. So this is truly a fascinating proposal. And I'm delighted to be joined here by Professor Christina Voigt, a renowned expert on international environmental law, Rizwana Hassan, a Bangladeshi lawyer and environmentalist, and Dr. Emma Carmody, an Australian environmental lawyer, on our panel today. Now, Matthew will introduce each of our panelists in more detail shortly, but I would say that both Christina and Rizwana are members of this prestigious 12-person independent expert panel for the legal definition of ecocide, which settled on a working definition of ecocide. And I'm looking forward to hearing from all of you on your insights into this. Now, before we turn to the formal introductions and thoughts from our panel, I'll just briefly set the scene for our discussion. Only 14 of ADB's 44 developing member countries are signatories to the Rome Statute, which is the treaty, as we know, establishing the International Criminal Court. However, within that group of 14 signatories, About half of those are island nations. And this is why I think the concept of ecocide is likely to resonate, particularly given the proposed definition of ecocide that would cover serious and persistent damage to the environment. And indeed, 2 of these island nations have actively argued that the crime of ecocide could address some of the injustices stemming from climate change and environmental crime. In December 2019, both the Maldives and Vanuatu called for an amendment to the Rome Statute to include ecocide as an international crime. Now, other countries in Asia have criminalized ecocide under their domestic laws. So, for example, in Armenia, Georgia, Kazakhstan, the Kyrgyz Republic, Tajikistan, and Vietnam, ecocide is punishable under local criminal law. Recently, the Bangladeshi High Court has asked the government to include ecocide in their International Crimes Act. And this was arising from a recent case where Rizwana represented the Bangladesh Environmental Lawyers Association. So, of course, some activity might be better and more appropriately addressed under domestic law. But having the international criminal legal framework address this issue, particularly for those acts which cross national boundaries and are of international concern for their severe, widespread, or long-term impact on the environment, will have greater normative significance, making it a valuable pillar supporting sustainable development. Now, investing in and achieving the Sustainable Development Goals contributes to the use of biodiversity and mitigating climate change. The urgency and magnitude of these issues are why ADB continues to scale up our finance for nature-positive investment, climate change, and sustainable development. In 2020 alone, ADB provided $21.6 billion in financing to support our members' delivery of the Sustainable Development Goals. ADB's Office of the General Counsel's Law, Policy and Reform Program also invests in strengthening the environmental rule of law in Asia and the Pacific, including through webinars like this. So, please join me in thanking this wonderful panel for joining us today to discuss this very interesting and important topic, the concept to introduce the international law crime of ecocide. So with that, thank you, and back to you, Matthew.
Thank you very much indeed, Damien, for putting that within the context of where we are with the Rome Statute and this proposed definition of ecocide. And so can I then turn now to Dr. Christina Voigt, who is a professor of law at the University of Oslo in Norway, and is certainly a renowned expert in international environmental law. And as Damien Eastman mentioned, she was on the panel, the 12-person panel that came up with the definition. Now, Christina Voigt is also completely passionate about legal issues on climate change, environmental multilateralism, and sustainability. She is the chair, the newly incoming chair of the IUCN World Commission on Environmental Law. And for more than 10 years, she's also worked as the legal advisor and negotiator for the government of Norway in the UN climate negotiations. She is currently the first co-chair of the Paris Agreement's Compliance and Implementation Committee. It's with great pleasure that I would ask Christina to say that the screen is now yours.
Thank you so much, Matthew. Thank you, Damien, both to you for this kind introduction. But first and foremost, thanks to the Asian Development Bank for convening this webinar series and for convening the TTT program in general. I've had the pleasure of hosting one of the IUCN Academy on Environmental Law colloquia here in Oslo a couple of years ago, where I could see in practice how well this is working and how valuable it is to professors and students alike. So congratulations to this program as well. Now, coming to the topic of today's webinar and the ecocide definition that was proposed, let me just take one step back. The idea of ecocide, of course, is not new. It didn't start with the definition that was launched earlier this year. It was something that's going back almost 50 years, if not longer. One important announcement was made by the then Swedish Prime Minister Olof Palme in 1972 in Sweden at the United Nations Conference on the Human Environment, where he alluded to the fact that the most severe environmental destructions and acts that lead to environmental destruction should be considered as an international crime of ecocide, and he actually used this term. In the meantime, in the last 50 years, different activists and scholars have worked on the idea of ecocide and on the concept. Most prominent among them, perhaps Polly Higgins, or late Polly Higgins, a barrister from the UK, who really elevated this topic on the international level. And it's also Polly who founded the Stop Ecocide Foundation, which is currently chaired by Jojo Mehta. Now, the Stop Ecocide Foundation reached out to 12 lawyers, international lawyers worldwide, including Rizwana here on the panel and me and 10 others, and asked us if we were willing and interested in joining an international expert panel, an independent international expert panel on the task of defining the crime of ecocide as a proposed international crime, a fifth international crime, with the purpose of amending the Rome Statute of the International Criminal Court. I personally met Polly Higgins. She was here in Oslo and held the Arne Næss chair in 2013, and I had many exchanges with her. So for me, it was no question when I was asked to join the panel to accept this very important and intellectually challenging task. Now, the expert panel was established in late summer last year, 2020, and it was a very interesting exchange of ideas, and I hope Rizwana had the same experience. We were 12 people, 12 lawyers from very different backgrounds from all over the world. It was geographically well balanced, that panel, and it was also well balanced in terms of expertise and legal background. So there were lawyers with a criminal law background, public international law background, national law background, but also environmental law background. It was a well-balanced panel, and we worked for about 9 months until we proposed the definition. And as I said, the idea and the mandate under which we worked was really to make this proposal with the purpose of amending or providing a tool that would enable parties to the Rome Statute to consider amending the statute and including ecocide as one of the most serious crimes that is of concern to the international community as a whole. That's the ratio materiae under which the International Criminal Court operates. Now, the definition that we agreed on after 9 months of interesting discussions was launched on June 21st, I know 22nd this year, and I just put it on the screen so that everybody can see it just very briefly. I think you can see it. So the panel made the proposal to define ecocide as unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And in addition to this one paragraph, which has a kind of a chapeau-like character, we also included a second paragraph where we took it upon us to define in more detailed way some of the core elements of that first paragraph. In particular, what do we mean with wanton? What do we mean with severe, widespread, long-term damage? And what is the environment? All of these definitions were quite challenging, but maybe in particular wanton and environment. It was really interesting, and I come back to that in a couple of minutes, to see that there didn't exist a legal definition of the environment. So we included a science-based definition that you see all the way down, where we said environment means the earth, its biosphere, cryosphere, lithosphere, hydrosphere, and atmosphere, as well as outer space. So I stopped sharing my screen. I just wanted to enable everyone to read that definition because it's quite a complicated sentence. Now, when the panel met and elaborated. And unfortunately, we were never able to meet in person. We only had Zoom meetings and email exchanges. It would have been really nice actually to meet in person. We made a couple of choices. Of course, there were many different definitions that we could have proposed, but we made a couple of choices that in a way guided our work and our thinking. I'll just want to explain but 4 or 5 of those choices. There were many more, but I have to focus here. One choice that we decided to make is that we propose this definition as an amendment to the Rome Statute as an independent new 5th international crime. We could have looked at the existing crimes and amended them to the extent that ecocide could be included in one of the existing crimes, but we decided, no, we don't want to do that. We do not want to address or touch or open any of the existing crimes, genocide, crimes against humanity, war crimes, and crimes of aggression, because all these 4 existing crimes have a very difficult negotiation history. They are there for very particular purposes, and it would not be appropriate to suggest an amendment to those crimes. And that's the reason why we suggested an additional 5th international crime, in a way out of respect to the existing crimes already included in the Rome Statute. The second choice we which was very, very important to the entire panel, was that the definition should include not just harm to humans, environmental harm that also causes harm to humans, but environmental harm per se, that is not in any way or does not have to be connected to any damage or harm that humans face or claim. So pure environmental damage was something that we really agreed all upon and including. That is part of the definition, as you could see, perhaps, for acts that are illegal. I'll come back to that decision and that choice between illegal and wanton acts in a moment. But pure environmental harm is included. A third choice that we made was the architecture of the proposed crime. As you could see from that slide that I shared with you, the crime is now defined as one sentence, which is fairly general and abstract. And that was a very decisive choice we made. We could have included a catalog of different examples of actions or omissions. And there were certain proposals made in the past, for example, by Richard Falk and others, that looked at ecocide and defined a number of potential actions or omissions. We decided that this was not what we wanted, because we wanted to leave the definition, as I said, abstract in general, in order to capture a potentially wide range of acts and omissions and a wide range of actors. And we feared that if we had included a catalog of acts, it may have excluded some things that we were not thinking of. Even if it had just said inter alia, if you list something, there's a certain understanding that what you don't list may be excluded or may not be captured from that definition. And we didn't want to constrain our thinking or the use of this definition for any further future purposes by providing that more specific catalog. We wanted to keep it fluid and dynamic, also to evolve over time to evolving science, but also importantly to evolving legal regulations, both internationally and domestically. I come also back to that in a second. A fourth choice that we made was the threshold for environmental harm. From the definition, you saw perhaps that the threshold for environmental damage is severe environmental damage and widespread or long-term. This is in a way a deviation from the recognition of environmental damage that we already have in the Rome Statute in Article 8, paragraph 2b4, where environmental damage is already included, but in the context of military attacks. Now, in our thinking, to have the cumulative or conjunctive threshold of widespread and long-term would be too high of a threshold, because when it comes to the environment, we may have situations that are not widespread, but are definitely long-term, or the other way around, that you may have long-term environmental damage, but are not widespread. So we disjuncted or disconnected these two thresholds and included them as disjunctive threshold, which of course is lowers the bar to a certain extent for what is included in this definition. But for both thresholds, it has to be severe environmental damage. So that was a very, very important decision we made, and it was based on a long, long discussion within the expert commission. Now, the final choice that I wanted to highlight is the fact, maybe we already saw this in the video, that a lot of environmental damage, severe environmental damage, is caused by acts that are absolutely lawful, where we don't yet have any prohibition, let alone any criminalization on the domestic level, but where the environmental damage happens nevertheless, despite the fact that the act or the omission is covered by either national or international law. In particular, in international law, we have very, very few legal provisions in international treaty law or customary law that substantively prohibit certain acts, let alone criminalize them. And it doesn't look much better in many domestic systems. And for that reason, it was important to the panel to also include acts that are lawful, but nevertheless lead to severe and long-term or widespread environmental damage. But for lawful acts, we felt that we had to include another threshold criterion, and this is where wantonness comes in. For lawful acts, the definition requires that there has to be a reckless disregard of the environmental damage, and that the environmental damage has to be disproportionate or excessive in relation to economic and social benefits. But this only applies to lawful acts. Now, there has been quite a lot of discussion and criticism of this definition that we proposed. And some of the criticism was launched against this inclusion of wantonness and that proportionality test that we included there. But we felt that we could not jump or leapfrog from lawful acts to criminalization on the international level. There had to be some sort of balancing element in there, because it would have been a leapfrogging from something that's completely lawful to criminalizing it as a most severe international crime. And therefore we included that requirement there. Now, I think in terms of the choices that we had to make, I'll stop here. I just say a couple of words of what it would require for this proposed definition to actually end up as an international crime in Rome statute. I just use 30 seconds. The definition that we proposed is only a suggestion, is only a tool or instrument that states may or may not want to use parties to the Rome statute to move forward. What would be required now that only one party to the Rome Statute proposes the definition or anything else to the UN Secretary General in New York as a topic to be negotiated amongst the members of the Rome Statute. And then it would require a majority of members to agree on this topic to be negotiated. And it could then be adopted as a new fifth international crime by a qualified majority of 3/4. But it would only become legally binding for those parties that actually do ratify it in their national legal system. So it's a long way forward, and we'll have to see how and when states are willing to do so. But I stop here, and I'm looking forward to the other panel's comments and reflections.
Thank you very much, Professor Christina, for that overview of where the definition has come from, and that there were choices. I mean, there's clearly choices to be made. I have to say I've got so many questions, but I know so many other people have questions, and that reminds me, questions after the panel. You can either type your question into the chat box or use the reaction button to raise your hand, and we'll call on you as part of a moderated question and answer after the presentations. So we'd now like to go on to Dr. Emma Carmody. Now, Emma Carmody is an international environmental lawyer with particular expertise in water law and policy. She has extensive environmental experience advising nation states, government ministries, First Nations people, farmers and peak conservation organisations in Australia and international. Dr. Carmody is the managing lawyer of the freshwater program at the Environmental Defender's Office that has achieved some enormous successes in public interest environmental law over the last 30 years. And she is the sole legal advisor to the Secretariat of and 172 contracting parties to the Ramsar Convention on Wetlands. She also serves on the Strategic Advisory Council of the Alliance for Global Water Adaptation and is a former trustee of the Alliance for Water Stewardship International. She's listed in Best Lawyers in Australia in 2 categories, in water law and environmental and planning law, and was the 2018 recipient of the Dunphy Award for Most Outstanding Effort by an Individual at the New South Wales Environment Awards. The award was made in recognition of her groundbreaking investigative work as a water lawyer, which has resulted in multiple inquiries and reports, a royal commission, prosecutions, and significant reforms to water law in Australia, in New South Wales, Australia. I should say her work on water law made her a bit of a water superstar in terms of the really challenging some of the issues about how we manage our natural resources. So it's certainly with great pleasure that I now turn over the screen to Dr. Emma Carmody. Thank you very much, Emma.
Thank you, Matthew. I'm really delighted to be here, and I'd particularly like to thank the Asian Development Bank for organising this webinar series, and of course my fellow panellists. It's an honour to be presenting with them. I'd also like to acknowledge that I'm coming to you from the lands of the Gadigal people of the Eora Nation, and I'd like to pay my respects to Aboriginal elders past, present and emerging. I'd like to preface my intervention by noting that I bring the perspective of a practicing domestic and international environmental lawyer, and in particular, as Matthew pointed out, the perspective of a practitioner with expertise in the laws governing freshwater resources. And I hope it's a useful perspective. We are living in a time of unprecedented environmental decline and, in many instances, ecosystem collapse. In my own relatively short lifetime, I've borne witness to the melting of the glaciers in the Hindu Kush Himalaya, the annihilation of the Aral Sea, the irreversible destruction of groundwater systems supporting large swathes of the world's population, a global extinction crisis caused by unsustainable development, pollution, and associated habitat loss, and mass coral bleaching, including of the largest living structure on planet Earth, namely the Great Barrier Reef here in Australia. It also bears mentioning that in 2021, only 1/3 of the world's longest rivers remain free-flowing. The remaining 2/3 are fragmented by dams and other forms of development, which in turn threatens freshwater ecosystems and the people and animals that depend upon them for their survival. In sum, from east to west and north to south, certain members of our species have, through the instruments of modernity, wrought destruction upon the natural environment, the same environment that we all depend upon for our ongoing survival. But who is to be held accountable? This is the chief question posed by environmental lawyers and our clients the world over, and also one that environmental laws and the governments that pass those laws fail to adequately address time and time again. I'll explain. The vast majority of widespread environmental destruction is not caused by a single person or even a small group of people, and can rarely be attributed to a single event. Rather, environmental degradation of this magnitude is caused by the cumulative impacts of multiple, often thousands or even millions of people and corporate entities over a period of years or even decades. Over the course of this time, governments, prime ministers, ministers and bureaucrats will come and go, many of them either lawfully approving developments that contribute to this degradation or willfully turning a blind eye to unlawful activities that again contribute to, but are not normally the sole cause of, widespread environmental destruction. However, and despite this reality, environmental laws are largely drafted to regulate individual developments in isolation, while offence provisions apply to individual offenders, be they natural persons or corporations. Put simply, environmental regulation is, in my view, largely ill-equipped to address the primary causes of environmental decline and ecosystem collapse. However, in making this statement, I am acutely aware that there are exceptions to this rule, with large polluters such as Shell and their corporate brethren coming to mind, and I'll touch on this again later on. But now this brings me to the proposed crime of ecocide. The function of the law is, amongst other things, to maintain order and stability. An uninhabitable planet, a planet on which temperatures routinely exceed 50 degrees, entire island states disappear into the sea, and rivers and aquifers are over-extracted into oblivion, is not in any way conducive to ordered or fair societies or to equitable and peaceful relations between nation states. It is, to be frank, concomitant with chaos. It is therefore unquestionably time that humanity formally acknowledges that unlawful and wanton acts leading to widespread environmental destruction are so repugnant, so antithetical to the prosperity of our planet and species, that they deserve to sit alongside the core international crimes set out in the Rome Statute, namely genocide, crimes against humanity, war crimes, and the crimes of aggression. However, and before I propose possible scenarios that may meet the definition of ecocide, I'd like to briefly comment on some of the limitations of this proposed crime. The first of these relates to the jurisdiction of the International Criminal Court, or ICC. Specifically, only individuals may be prosecuted in the ICC for alleged breaches of the Rome Statute. That is, its jurisdiction does not extend to nation states or to entire corporate entities. However, and as I'll discuss shortly, it does in all likelihood extend to the directors of impugned corporations, and this is significant. The second of these relates to the nature of widespread environmental destruction, which, as I have already noted, is primarily cumulative in nature and the result of multiple acts committed by multiple individuals and entities over a period of years or decades. The Rome Statute and the proposed crime of ecocide cannot address environmental degradation of this nature, not least of all because it cannot be attributed to an individual or a small group of individuals. Upon reflection, though, perhaps an exception could be a dictator who has maintained his or her grip on power over a period of decades, during which time he or she has directly or tacitly authorised acts that have resulted in serious foreseeable environmental destruction. This is, of course, assuming that the dictator in question is from one of the 123 countries that have agreed to be bound by the Rome Statute, or has otherwise committed the purported environmental crimes on the territory of one of these 123 states. The third limitation is again a jurisdictional matter. That is, the ICC has no jurisdiction to arrest an individual alleged to have committed a crime under the Rome Statute. Rather, the court relies on the states that have agreed to be bound by the statute to cooperate with it in the event of an investigation and eventual prosecution. It is entirely possible that this cooperation will not be forthcoming. There are other possible limitations and challenges, including in relation to the gathering of evidence and the fact that the Statute of Rome cannot operate retrospectively, that is, before its commencement in 2002. Proving the mens rea or intent element of the crime of ecocide may also be difficult, including in relation to otherwise ecocidal incidents, such as significant oil spills. It's also important to note that the Rome Statute is not intended to operate as a substitute for national laws or courts. Rather, the ICC, in accordance with the principle of complementarity, will only intervene when national governments have agreed to be bound by the statute, fail to act, and assuming all other necessary conditions set out in the statute have been met. I'd like to dedicate the last 5 minutes of this presentation, however, to contemplating possible scenarios or categories of acts that may fall within the definition of ecocide proposed by my learned colleagues, and which may, in theory, be justiciable in the ICC should the Rome Statute be amended. The first category is large-scale mining developments, particularly in the Global South. There are numerous examples of large, horrendously toxic mining operations across Asia, Africa, and South America in particular that have effectively poisoned entire river systems and destroyed large areas of previously intact forest. The question is whether the ICC would or could prosecute the directors of the responsible companies, the ministers who authorised these developments, or a combination of both. Shell, BHP, and a number of other large corporate luminaries have the ignominious distinction of falling squarely within this category. The second proposed category relates to an individual development that destroys or severely degrades what was previously a significant intact ecosystem. This could include, for example, a large-scale hotel or residential development that destroys an entire internationally significant wetland, or a logging operation carried out by an individual corporation that destroys large swathes of an ancient biologically significant forest, or logging carried out by several actors but approved by a single minister, for example. The third scenario relates to a single large-scale irrigation development that draws all of its water from a single given aquifer. Where such a development destroys the aquifer and a significant percentage of any associated groundwater-dependent ecosystems, it may be possible to argue that the responsible individuals, for example, the responsible company directors and any associated government officials who are responsible for approving the development, it may be possible to argue that they've committed an act of ecocide. By way of brief conclusion, I'd like to reflect on the strangeness of our species. On the one hand, we are capable of building extraordinary civilizations and of creating life-changing art, music, poetry, medicine, and so much more. On the other, we are capable of wanton destruction, including of our natural environment. If our legal system is to have any moral force, it must reflect this reality. This is why the proposed crime of ecocide is so vitally important, in my opinion. Thank you.
Thank you very much indeed, Emma. And I think the questions that you've raised are certainly some of the questions that I think I sort of think about as a sort of national environmental practitioner. I also think that that's one of the reasons why, for us, we put this as part of a package looking at sort of civil compliance. We've had 2 webinars looking at environmental crime and environmental criminal compliance and the national thing, because ecocide is seen very much, if it comes to join those crimes against humanity, genocide, war crimes, they are special and extraordinary crimes. But as you say, it is for that condemnation about the repugnance that is antithetical to society and to civilized behavior. And I think this is also where we see this in all environmental crime. The importance thing, whether it's wildlife crime or pollution or waste crime or crimes against cultural heritage, to increase these offences, to focus these offences, is to demonstrate that these are acts that are repugnant to society and to our civilized norms. So I would now like very much to turn to our third speaker, and again, it's a great honour to be joined by Rizwana Hassan. Rizwana was also on the drafting panel, and indeed she is one of those environmental law champions that possibly need no introduction. But if Rizwana will allow me, I will indulge myself a little bit by explaining what an extraordinary advocate she is. Rizwana Hassan is an enrolled lawyer with the Supreme Court of Bangladesh. In her professional life, she's working for the cause of environment as the chief executive of a reputed national non-government organisation named the Bangladesh Environmental Law Association. Her main focus is to promote the notion of environmental justice in Bangladesh. Rizwana did her master's and graduation from the University of Dhaka with distinction, and she started her career with the Bangladesh Environmental Law Association in 1993 until today is continuing as the Chief Executive Officer of that organisation. Her work in environmental law is quite simply legendary, but as an environmental lawyer, Rizwana has led successful legal campaigns against the filling up of wetlands in around Dhaka and by unscrupulous housing companies, commercial and forced shrimp cultivation, depriving the farmers of their traditional agriculture, depriving forest dwellers of their traditional forest rights, vehicular pollution, industrial pollution, and so on. She's attended more than 100 regional and national seminars and workshops as a resource person. BELA, the Bangladesh Environmental Law Association, has received the Global 500 Roll of Honours of the UNEP in the year 2003 and has won the Environmental Award given for the first time that year in 2007 by the Department of Environment for popularising environmental law. Rizwana herself has received the prestigious Goldman Environmental Prize for the year 2009 for her outstanding contribution in protecting and conserving the environment of the country. She was named as one of the 40 environmental heroes of the world by Time magazine, and recognising her impassioned leadership, hard driving skill and uncompromising courage in the campaign of judicial activism that has demonstrated that the right to environment is nothing less than a people's right to dignity in life. Rizwana was awarded the Raymond Magsaysay Award in 2012. So it's a great pleasure to now turn the screen over to Rizwana for her observations and comments. Thank you very much, Rizwana.
Thank you very much. Thank you so much for inviting me. Do you hear me clear?
Yes, we do. Thank you very much.
I'm actually returning from the court, so if there is any problem in hearing me, please do let me know. I'm also keeping an eye on the chat box.
Thank you very much.
Let me just try to give you all an idea about the environmental justice situation here in Bangladesh and why I agreed to be a part of the panel that drafted the Ecocide definition. I don't think any legal system will ever be perfect. There will always be challenges, but it's important to also appreciate the moral force behind the initiative. And I'm really very happy to see the enthusiasm all over among the environmental justice advocates about having this ecocide definition recognized and incorporated in the Rome Statute. I live in a country which is the 8th most populated country of the world. It has a very small landmass, but has a very vast coastline. We host the biggest mangrove forest of the world. We share it with India, and our beach is the longest unbroken sea beach of the world. Although we are very populated, our farmers have actually managed to grow the staple for all the Bangladeshis. And most of our people depend heavily on natural resources for their living. However, these natural resource bases, which are the livelihood source for many of the Bangladeshis, for majority of the Bangladeshis, are under severe threat from the very fast track of development that the government is pursuing. And this track of development is not something that we have designed together with the government. It is something that has been imposed on us, and we do not have a proper democratic governance in the country because there is widespread allegation that the last 2 elections were largely rigged, and most of us did not even manage to vote. So we have this problem of democracy, and we have the problem of natural resource management, and these problems are being created in the name of development. We had to sacrifice our democracy because the government pleads that it is doing a lot of development for the country, and the slogan is as if you need development first and democracy. With the environment front, it is the same thing. You need development first and then protection of environment. And in the process, what's happening is we are inhaling the worst air of the world. So sometimes we are first, mostly it is Delhi that is first, then we are second, and then Lahore. The competition is between Delhi, Lahore, and Dhaka. So we inhale the worst air of the world. Our rivers are among the worst polluted rivers of the world. Our deforestation rate is 2.6%, which is double the global deforestation rate, which is 1.3%. Our total forest cover claimed by the government is 11%. We would say it is a maximum of 8%. 90% of our agricultural land is contaminated with chemical and toxic laden and heavy metal. And these are figures that I'm giving you from either government statistics, government reports, or from reports done by UN agencies like FAO. Because most of our rivers are polluted, farmers are not getting enough water for farming their lands, and people are actually suffering from want of potable water. And because of all these facts, these are the national issues we are faced with. In addition to that, we have this pressure of development that are being imposed by different international players. You know about the shipbreaking industry in Bangladesh. It is surviving here in the South Asian countries, and Bangladesh is one of the South Asian countries because of the very fact that our regulatory regime is very weak. Our laborers are cheap, and our environmental law enforcement also is very weak. And the EU countries, the other developed countries, are most happily sending their heavily toxic laden vessels on the beaches of Bangladesh, which they would never do to their own beaches. They'll never do to their own people. We are having thermal power plants. From 1, we jumped to 28, but because of the campaign by the environmental justice advocates, the government found it difficult to get funding for 10 of the thermal power plants. So the government scrapped those plans, and the government is now saying that they have done it in consideration of climatic impacts. But had that been the case, then all 28 should have been scrapped, not only the 10. It's because of the fact that the government is not finding the financial agencies to support those plans. There are huge projects being undertaken, and those are marred with corruption on one hand, and on the other hand, they're destroying our forests, our hills, our rivers, our biodiversity, and in the process, millions of people are losing their cultivable land. We are losing different species that are disappearing from Bangladesh, and all these projects that have international finance involved are actually being undertaken in gross violation of national and international law. We have a very weak regime on the environmental impact assessment that would have allowed us some scope to participate, but the fact remains that these have become just paperwork. So these are greenwash tactics, I would say. And our environmental performance rank out of 180 countries remain 162. And our performance in rule of law is 124 out of 139 countries. So we are in a very desperate situation so far management of natural resource and environmental protection is concerned. At the same time, Bangladesh is one of the 50 most vulnerable countries of the world if climate change happens, to which we haven't contributed a bit. We will lose the entire coastal belt of Bangladesh, already a very small country with huge population, and our capital has a staggering population of 47,000 plus per square kilometer. So we will lose 21 of our coastal districts, which means that for a problem that we have not created, we will be forced to draw the map of Bangladesh differently. And it is in my generation, and my children will definitely be drawing the map of the country very, very, very differently if we do not do enough on that. All these offenses against environment are being committed with full knowledge about their consequences. They are being committed not with full knowledge about their adverse consequences, but also with full knowledge that alternative and safer technologies, alternative and safer processes, alternative and durable mechanisms exist. So you on one hand are ignoring the adverse effects, on the other hand, ignoring the fact that there are alternatives that are there. So picking up from my previous pickup, it's not only about dictatorial, perhaps having a dictator who is doing things, it's also about how arbitrary the decision-making process is. There are many international environmental laws, and most national environmental laws in the developing countries define environmental problems as crimes, but because of the fact that the judiciary is not very independent, or the judiciary has been deliberately made subservient to the other government agencies, justice is often not being delivered. So you have the right to life recognized in your constitution, which includes your right to environment, and you also have a constitutional protection for environment. But however, we are not getting justice, and this is because the government is overprotective. I mean, it's not a dictatorship that we have here, but it's dictatorial when it comes to defending its own development agenda, which definitely is unvetted, and people had no scope to participate. So we do have oligarchs who are regulating the real estate sector, the energy sector, the transportation sector, the agricultural sector, and these are both national and international players. And recently we are seeing that the attack on the environmental human rights defenders actually on a very alarming rise. Considering all this, and today in the newspaper I just read that there has been a study that says 1% of Bangladeshis own 40% of our national assets. Unbelievable. So it is that degree of inequity, and many of them actually are committing environmental crimes, and they are doing it just for their own financial benefit. So I think it is a call of the time that we define ecocide, and we create an international platform, or get or kind of an international platform is made available
Sorry, Rizwana, you've frozen a little bit.
Ecological crime managed to get the
Sorry about that. We seem to have lost Rizwana. She was coming back from the court, and when Angelo, if she reappears, Rizwana, would you like to make your concluding point? Yes, please continue. Yeah, thank you.
This will actually be creating huge pressure on the perpetrators. It will force a change in the political vision about development. So the transformation that we ask for might happen. I mean, the process will begin, and it will be very empowering for the victims. And I would say that even if the process of the ICC is slow, it is always better to have it later than not having it at all. Thank you very much.
Thank you very much indeed, Rizwana, for that those observations. So I'm now happy if we could open up and spotlight the panel, if that's possible, please. And if anyone would like to ask a question, if by clicking the reaction button and raising a hand, and then or in fact writing any questions in the chat box. I guess I would, if I could just ask, and maybe Damien, if I can also ask you this particular question, and Christina, within the Asia Pacific region, and certainly the area of the Asian Development Bank sort of focus, we were looking at the number of countries that were actually members of the Rome Statute, and interestingly, Law Asia at its annual conference had the chief judge of the International Criminal Court talk about the Rome Statute, or sorry, the Chief Registrar talk about the Rome Statute and the ICC and in terms of jurisdiction. is this also potentially a mechanism we can use to identify countries and support countries that may wish to accede to the Rome Statute, given that I think it's only 15 or 19 countries within the Asia Pacific region are actually members, have actually signed up to the statute? So Damien or Christina, from that structural point of view, do you think that this is one issue that could also help focus attention on accession and implementation of the Rome Statute?
So Matthew, why don't I just jump in to begin with, and perhaps Christina can follow on. I think ADB certainly has played a role in helping our developing member countries accede to sort of relevant international conventions where that international convention is sort of, related to our sort of economic mandate, if you will. And so I think that, where I would foresee a role for us, certainly, perhaps later down the track, that, once this good work has done and, if it sort of blossoms into something that results in an amendment to the Rome Statute, then I think, certainly under the rubric of that sort of ecological and environmental crime, we could be making a very strong argument that our TA resources and assistance is relevant to assisting our developing member countries accede to the Rome Convention. So certainly down the road, that's something that we could certainly look at, and it would certainly be in keeping with the work we have done with many of our developing member countries to help them to accede to international conventions that are relevant. So, for instance, our law policy and reform program, we've spent the last 3 or 4 years assisting many of our developing member countries in the Pacific region in particular accede to the New York Convention. And, that's a whole other seminar we can talk about. But they would be my initial thoughts. I don't know whether Christina wants to add to that.
Thanks, Damien. I think one additional point is that, I think this new, if there's this new crime, it could be an impetus for additional ADB developing member countries to accede. Not that the other crimes aren't as heinous, but it could be an impetus because, environment is at the center of the development agenda for our developing member countries. So I think they will definitely be watching this space. And as Damien said, we do help accede to relevant international treaties upon request. Thanks.
Thanks. And Professor Christina, did you want to make some observations? I mean, especially given the background that you've had over the last decade in the climate negotiations, which clearly, as climate change has become a fundamental issue, and certainly for many island states, it then has led to the impetus to transform economies and transform the way people respond to climate change as a matter of very existence in some respects. So is this something that perhaps this discussion on ecocide can lead to a greater discussion on the role of international norms and the relevance to states, emerging states, developing states?
Well, we've heard, of course, the strongest voices supporting the idea of an amendment of the Rome Statute to include ecocide do come from small island developing states who apparently see a tremendous value in adding environmental destructions to the most severe international crimes. So we see that there is this concern where we don't really have any other international forum, like Rizwana also and Emma explained, where we don't have any other international forum that could address that kind of behavior. And if that interest and the whole discussion around an amendment of the Rome Statute leads to additional accession to the statute, that would be fantastic. Now, I've been in many discussions around this ecocide proposal, and what I usually hear is that the Rome the International Criminal Court is of course not without criticism, and we've seen states withdrawing from it for very different reasons than what we're talking about here. So if that new discussion could actually kind of reverse that trend, and also the focus on what that court could do and what kind of injustice or injustice it could address, maybe getting more states to join it rather than leaving it might be also enhancing the legitimacy of the court itself.
Thank you. And we have a question from Gong Junming. Would you like to unmute yourself and ask your question?
Yeah. Hello, respectable professors. I come from China and I'm undergraduate, currently writing an article about criminalization of ecocide. And I, sorry, I doubt my question is quite profound, but I just want to ask the Professor Christina Voigt. I know the panel have already submitted its report on the draft amendment, but I just want to know whether in the future the panel will continue pursue amend its draft amendment, like the first or second reading of the report, or just this panel will be dismissed and leave the state parties to further discuss. Because I know the last time there's a new amendment that's the crime of aggression. That kind of it takes 7 years to be officially amended. So I want to know in the future whether this panel will be will still exist and continue to participate. Thanks.
Thank you for your question, and it's an important one because there's maybe a bit of uncertainty about what this panel was and its function was. But as I said initially, we were asked by the Stop Ecocide Foundation, and non-governmental organization, to help draft a proposed definition. That was all we did. That was what the 12 panel members delivered upon this mandate. And it is now, it's out there, it's public knowledge. It's something that can be used by states if they find it helpful and meaningful to pursue it further. But the panel itself has delivered on its mandate. What the individual panel members do, like the panel, for example, was chaired by Philippe Sands from the UK and Dior Fall from Senegal, and many others. They're still very active and engaged in different discourses, both on the national and the state level and non-state level. That is a different story. But the panel as such was an independent panel. It was not a formal state-based negotiation, and we in a way delivered on our mandate, and that's for that panel is closed its task.
Okay, thanks. I really appreciate your comment, and I'm looking forward that there will be a future development of this panel and this foundation. Thanks.
Thank you. And I think Rizwana has rejoined us, so if you can be spotlighted, that would be great. Thank you. So there is a couple of questions. One is about timeline, whether there's any timeline for it to be officially adopted. And I guess one of the other questions we also have is about that idea of the list, and why was it, sort of a bit more explanation perhaps as to why the wanton and severe broad definitions of environment were chosen over a sort of a list of crimes such as climate change or other identified crimes. And I guess one of the other questions I would like to ask Emma about, in terms of, water is clearly, one of these fundamental issues that affect the Asia Pacific, and whether it's rivers such as the Salween and the Chinwin and Ayeyarwady, the last great rivers in the Mekong area that are undammed, and there were obviously a lot of discussions about the dams on the Mekong, and people were arguing that those early dams were actually crimes because of their massive and significant impact on the environment downstream. one of the questions would be, would that be potentially a crime acting in a way that causes severe ecosystem collapse and damage through major hydropower developments, which are obviously relevant to most of South Asia at the moment. So perhaps Rizwana and Christina, perhaps we could talk about, you know, the broadness of the definition as opposed to listing things, and then maybe thinking in that context of water law in protecting ecosystems in rivers, which are, you know, obviously already under threat from climate change issues, which then I guess raises that issue about the cumulative impact, whether that would fall within the definition of widespread and long-term, perhaps. I know there are a lot of questions there, so sorry about that.
I don't know when I'll again lose connection, but for me, instead of listing things, keeping it open-ended and broad makes sense, because the nature of crimes keep on changing, and a lot would depend on the leadership. I mean, if it is accepted as a crime, a lot would depend on the leadership in the panel, not our panel, but in the judges, I mean. So we were from the very beginning. I mean, I don't think we spent much time on taking a decision about this, that whether we want to list things or we want to keep it, you know, open-ended and broad. I think that was rather an easy decision, no? My other panelists can assist me. I think that was rather an easy decision, but in terms of whether to call it both severe and long-term and widespread, I mean, should you have all the criterias as tests, or we should rather be limiting those, was the debate that took most of our time. So I'm personally very happy that we did not list things.
Yeah, I mean, I completely agree with Rizwana, and I already explained a little bit about the thinking, whether to include a catalog or list or not. We feared it would be too limiting and exclusive. You know, by everything you don't list, you kind of exclude it. And that was a danger that we didn't want to take, given, as Rizwana said, this is a dynamic field, both of science and of law. And there may be things that lead to environmental damage that we were not thinking of yet. And we were afraid that we would buy a list that, you know, set things in a way in stone, but we wanted to keep it dynamic so that it could evolve over time with evolving science and law, and also not to exclude something. And we kept it general and abstract for the purpose of covering a wide possible range of effects and impacts, but also of actors. So it was something that we wanted to keep open for, as Rizwana said, not just the court, but also the office of the prosecutor at the ICC, if we ever get there, to leave it, you know, to work with that definition and adjust it to particular crimes at hand.
Emma, would you like to sort of talk about you know, some of the water law issues and whether they would be potentially relevant as crimes?
I mean, one of the, or probably the most significant issue, or most frequent issue that people contact me about, people who are activists or advocates in Asia, would be the impact of hydropower on rivers. But often they're contacting me because of the impact on wetlands, which are invariably destroyed when you dam otherwise or previously free-flowing rivers. And people are often very frustrated because I have to explain that international environmental law depends entirely on the willingness of contracting parties to the relevant multilateral treaties to implement the treaty. And they're framed, or they're drafted in a way that gives contracting parties significant scope to choose how to implement them. And I have to explain that the Secretariat of the Ramsar Convention, indeed of other multilateral conventions, has no jurisdiction to enforce the treaties or to persuade those countries to implement the treaties in a particular way. So that's the background about some of the limitations of international environmental law. And if we turn to the possible role that Ecocide could play, if it were incorporated into the Rome Statute, it could go some way in filling that gap. And I think hydropower is probably an example of where an individual development that is undertaken by an individual developer and approved by a specific minister or small number of government officials could fall within the definition, because I do see issues with the cumulative impacts simply because you can't attribute them to a small number of people. Others might have different views on that.
And I get just following up, and we've got a question, hand raised by Tariq Fayaz. So Tariq Fayaz, if you'd like to turn on your camera or turn on your microphone, please ask your question. But can I just first follow up a little bit on that issue of cumulative? And I attended the briefing and the launch of the definition. And I think one of the points that was made by Philippe Sands was that the idea of the environment was not only harm, but it could be apprehended harm. Is that's still sort of part of the idea? Is that correct, sort of Rizwana and Christina?
Yeah, absolutely. If you see the definition, it talks about unlawful or wanton acts committed with knowledge that there is substantial likelihood of severe, widespread or long-term environmental damage. So it is also something that is apprehensive, and you don't actually have to have the harm. How this then is going to be implemented, prosecuted, that's a different story. But the intention behind the definition was to be preventive as well. Yes.
And thank you. Tariq Fayaz, please.
Hello everyone. It's an ensemble of the panelists, and I'm lucky to put questions. My name is Tariq Fayaz. I am a PhD scholar at the Indian Institute of Technology, Kharagpur, and my research area focuses on the illegal, unreported, and unregulated fishing in the Bay of Bengal region. And with respect to the crime of ecocide and being included in the fifth, as a fifth crime in the international statutes, how far do we think that considering that there have been reports that the number of fish in the world oceans will be lost by the year 2048, according to the Springer Science Journal. So sometimes these acts are wanton, sometimes these acts are legal also, sometimes these acts are, the definition itself in the illegal, unreported, and unregulated fishing is still nascent in its stages. So how far do we think that the fish being the most important source of protein for around the world, and considering my question is to Madam Rizwana as well and to Professor Christina, that how do we think that we are going to curb this menace of illegal, unreported, and unregulated fishing within the Bay of Bengal region, of course, of which I'm taking Bangladesh also as a country. My focus area is also India, Bangladesh, Maldives, and Sri Lanka. These 4 states which form part of the Bay of Bengal intergovernmental panel on it's an RFMO which takes care of the fishing industry. So how do we think that these aspects of the IUU fishing will fit into the international statutes fifth crime? Thank you so much.
Thank you.
Should I?
Please.
See, we are all enthusiastic to take all our environmental issues before the ICC, but that is probably not the idea behind it. The idea behind the proposal of the Ecocide is that whenever you are not getting domestic legal remedy, only then you are going to ICC. And when the issue is of some given magnitude, I mean, it's not something localized, but it has, affected a larger community or a bigger landscape, and you are unable to get relief at the domestic level. And also one has to bear in mind that it's a crime that is committed by one individual. So you have to really point to few individuals who are responsible behind creating this, and whether this is actually defined as crime, it suffices as crime, or it's just a natural resource management issue, and also the magnitude of the issue. If these three tests satisfy, then you probably would be able to take it to the ICC. You have to first identify not only the criminal act, but also the criminal behind it. So we'll have to see how it goes.
And just following up on that, was a question also in the chat box about climate change. And I think that has been addressed, that potentially climate change, if you can identify the criminal and climate change, you'd have to identify what aspect you were dealing with. The question then also is asked about the Rome Statute applying to the activities by business, and why it cannot, or why the definition focuses on the individual as opposed to corporate responsibility.
I can just say a couple of words about climate change, because it's, of course, it was one of the most important aspects that we worked with or struggled with. At one session when we met, each panel member was asked to, look at or suggest one particular act that possibly could fall under the definition. And it was quite an interesting thought experiment that we did. And climate change is difficult for several reasons. As Emma already mentioned, the court's jurisdiction is not retrospective, so it cannot go back in time. Much of what we're currently seeing in terms of global warming and climate change impact is caused by past emissions. So what we would have to look at is, things that happen from now, basically once this definition amendment were adopted from that moment onward. But it could perhaps include large-scale coal development or oil development that has a potential for large amounts of emissions, and we know now where this is going. And since Glasgow, the climate COP, we also know that coal is something that is out of the economic system or on its way out. So there's a possibility to capture large fossil fuel developments in the future that contribute to climate change significantly, but that is not something that we can look back in time. That is something the ICC just doesn't have jurisdiction over.
Yes, Rizwana, thank you.
As an environmental justice advocate, I am excited to experiment suing one individual who holds office, is aware of all the scientific evidence, still denies to sign the Paris Agreement, and continues to engage in activities, in projects, in processes that are detrimental to the climate system and that are carbon intensive. I personally would like to test that case before the ICC. So I think because mens rea is very important here. So if I can establish that this particular act was done after having full knowledge about the adverse consequences, about safer alternatives, and you knew what's going to happen. No, so I think the small island countries are already planning to take their grievances before some international platform. So it is possible that failure to defend the rights of the small island countries by wanton acts with full knowledge can be taken before the ICC.
Thank you. And I think Vanuatu is already considering its advisory opinion from the ICJ. So Emma, I mean, just in terms of this idea of corporate criminal liability, companies seem to be committing a lot of environmental offences, and often at a global scale.
Well, I wrote my environmental law thesis in 2002, and it was precisely the issue that I examined. And what I found at the time, unsurprisingly, was that international law was ill-equipped to deal with this particular issue because it primarily regulates conduct between nation states, with some exceptions. My understanding with respect to the Rome Statute and the jurisdiction of the ICC is that at the time the statute was being negotiated between various nation states, the idea of including a specific article relating to corporate responsibility was contemplated, but it was ruled out. The parties were unable to reach an agreement, and it would have really been too complex to attempt to pursue that any further. And I think at the time when it came into force, and certainly when it was being negotiated, environmental criminal law at the domestic scale was relatively immature, and international law operates in accordance with the principle of complementarity. So it's not necessarily looking to propose entirely new areas of law that have never been contemplated before domestically, or are so far beyond the realm of what is being contemplated domestically. Now it's very different because many countries have very well developed offence provisions in their environmental statutes. The problem, as Rizwana pointed out, is one of enforcement, and it's an issue all over the world. And in 2019, the UNEP put out a report entitled The Environmental Rule of Law. It was the first report, and what they found was that whether it was in the global south or the global north, whether or not the country had incorporated environmental rights of varying persuasions into their constitutions, whether or not they had well-developed environmental laws, enforcement was typically poor. And I can say it's a problem in Australia, which is one of the wealthiest countries in the world, and it's particularly problematic in a country like Bangladesh, which Rizwana described. I was quite in awe of you, I have to say, talking as you were coming back from work in the car. So what I see here is an issue of implementation, but just to really circle back, my understanding was that they contemplated it at the time. It was ruled out because it was too difficult, and at the time there was just it wasn't particularly well developed at the domestic scale. And I don't know now whether it would be possible to amend the statute to explicitly include provisions that extend to corporations, though I do think that individual directors of corporations could be liable.
And so, I mean, following up on that as well, I've got a question from Bryony Eels that the ICC has been criticised in the past for slow prosecutions. Assuming ecocide is adopted as a crime, how does creating a crime contribute to or benefit environmental law governance domestically? I guess that's the optimistic idea of once we get this crime, what do we do with it?
That's a very, very good question. And I think the answer is that it alone, the discussion around this definition and ecocide has shown that it has ignited some initiatives domestically in several countries, some parliamentarians getting together in Belgium, in Sweden, in different countries, looking at domestic law and the revision of domestic penal codes or constitutional provisions. And I think that in itself, that change in consciousness and also focus on the domestic legal system is a very important outcome already, even though the definition is not adopted. But the discourse itself has helped to make this discussion more palatable to domestic lawmakers. And I think that is actually where the change needs to happen, and the enforcement needs to happen before we can talk about the value of an international level to it. Changes domestically, and if this is ignited by this definition, that's already a success, and it would lead to governance changes that are probably much more broad and far-reaching than the international level itself. I just had a very brief comment to your previous point, Matthew, on the possibility of an advisory opinion by the International Court of Justice that is now pursued by Vanuatu and others. I mean, try to go to the United Nations General Assembly, and that is the first step that we don't know how it goes. But there's also another initiative by the Small Island Commission on seeking an advisory opinion by the International Tribunal on the Law of the Sea. So different channels are being pursued for an advisory opinion. And these advisory opinions wouldn't be legally binding, but they could be an indication of what is legal or lawful conduct and what is not lawful conduct by states in these two particular examples. And that again may have an interesting dynamics with the proposed definition, where we said, it's unlawful or wanton acts, and the unlawful bit is something that is now dynamic. Currently, not that much is unlawful, as Emma also said, under international law. But these advisory opinions, if they go forward, could help crystallize and identify where is the limit between lawful and unlawful behavior, and that could then play into the the future development also of ecocide and its applicability. So there is, although they're completely different channels, there's an interesting legal continuum.
And I think, I know you're a passionate advocate for good rules of procedure in environmental courts and tribunals, and you've written a lot on the role of courts and tribunals. So for me, that's something also that the Asian Development Bank does do with its partner countries in trying to look at general environmental law principles and rules of procedure and rules of practice for environmental cases. Something that Emma and I have well experienced in terms of our New South Wales Land and Environment Court background. I'm also interested, Christina, do you think that this will potentially lead to a possibility that the criminal court will look at special rules of procedure for environmental cases that are brought before that? Do they need to be characterized individually or especially because of some of those particular issues arising from the definition, assuming that it's adopted?
Possibly. Of course, you have to take one step at the time and see if that definition, sees the light of the day at the Rome Statute or not. And then the second question is, what if it does it lead to different or changes in the procedural rules, especially when it comes to expert scientific proof and so forth, which in environmental issues may be very, very different to the existing four crimes, and something that the International Court of Criminal Court hasn't dealt with. But I don't know. It might be wise to look at this when the time comes, but I think we have to see first step first before that is becoming an issue. But it's worthwhile thinking about it.
Thank you. And I noticed the time. Enrico Bosco has been waiting a little bit. Can I just ask him to call, and then I'll sort of ask our panelists if they'd like to make a concluding statement and then wrap up by mentioning some of the other comments in the thing. Enrico Bosco, are you able to unmute yourself and ask your question?
Yeah, sure. Thank you so much.
Thank you.
Yeah, I'm Enrico Bosco. Are you guys listening to me?
Yes, we are.
Yeah, I'm Enrico Bosco from Uganda. Actually, I'm the founder and the CEO of Green Home Transformation Limited. I am so pleased and so super excited to be here. First, I just want to maybe put some little things in thought. I remember 4 years and a half ago when me and my family, we were trying to actually lay bricks from the land, using the soil. We dig lands, and then we actually lay bricks for the school fees and lay bricks for the for the home consumptions. And also I was also engaging some youth to actually be involved so that they can generate some money for their personal things and also their requirements to go to schools. And then later on, when I look at that, it was so actually spoiling our environment. Then I thought of looking at another alternative, like we have other problems like plastic waste. The waste are so much in Uganda. If you see statistically, we have something like in my town, we have 20 tons that they actually released on monthly basis. So I thought of coming up with a formula of recycling this plastic waste into sustainable alternative construction materials like bricks and pavers. But later on in this process, we had a lot of challenges. We had to prototype our products using rudimentary tools, whereby you find that there's a lot of smoke emissions in the process. And then I started thinking twice now, what can we do right now? It's like we are not saving environment. It's like we are just trying to give more burden, we are destroying the environment the more because the smoke emission is too much, seriously going up there. And then when I try to move around, ask for help so that I should look into machines which is environmentally friendly for this process, but you find that the challenges could be finance for someone actually to come out with a good technology, but they are really in need of doing something, but the finances not there. Now they ended up actually degrading the environment. So specifically, I think at times people intend to do something not for bad, but at times they look at the way of maybe they need to reach somewhere. As you see right now, when we try to reach local governments, they're every time something like now 1.5 years, they're giving up promises because we made the partnership with School University. They have now given us a design for environmental friendly machines, but they're waiting for the funds to fabricate us the machines, reaching out the local government. We are still down, no response, 1.5 years down the road. So now, instead of giving work to people right now, I cannot, because until I acquire the environmental machines. I don't know, maybe someone has something to talk about this situation, but right now I'm almost down. I'm not operating because my operation procedures are not environmentally friendly, and I really need to operate in environmentally friendly manner. Okay. Thank you so much.
Thank you very much, Enrico. Thank you. So if I can sort of turn to the panel and thank everyone for your participation and your comments, and just to provide you with a sort of a minute or so to as an overview of where you think the ecocide debate will go and what value it can bring in terms of environmental rule of law. So Rizwana, would you like to go first?
My thinking process is still very disorganized. I had to deal with 5 cases today on different issues. But I think when we try to define ecocide and make it a mandate of ICC, I personally do not look forward to a huge number of cases. I rather want the whole thing to act as a deterrent force and as an alert to the perpetrator and the abusers. Even if it is not accepted there, or there are so many procedural complications that with the definition accepted, you can't really get the relief that you're looking forward to, the fact remains that a crime has been defined. We are pointing finger to the criminals, and we are actually demanding a change in the system. To me, that would be a huge success.
Professor Christina.
Yeah, I completely second what Rizwana just said. I mean, the International Criminal Court cannot save the world from environmental destruction, and we cannot expect it to do so. But as I said earlier, this discussion alone has shown that it has led to some changes, and they may continue. And if the amendment were adopted, the possibility of committing an international crime would have a significantly deterrent signal and effect on both, corporate, those are responsible for corporate actors or states, ministers, and so forth, decision makers. And I think this alone, that change in consciousness, that deterrence against these environmental harms would be a very, very significant input into governance changes and changes in behavior, and that in itself would be a success.
Thank you. Dr. Emma.
I wholeheartedly agree with Rizwana and Christina. Thanks so much for your interventions and comments. I think one of the kind of existential challenges with environmental law is that invariably involves the intersection between protection of the commons on the one hand and profit and private property and personal gain on the other. And that's an enduring problem, and it can't be resolved. There's no single solution. It can't be resolved with one law. And to that end, I do agree that this is one tool in a toolkit of different approaches that we bring to this complex set of issues that is environmental law that environmental law tries to address, and environmental degradation. I guess I'd also return to the point I made in my presentation, which is that essentially the law has to hold up a mirror to society. And if it's going to have any moral weight or any force whatsoever, it has to reflect in a meaningful way the core issues of our times. And environmental degradation, for me as an environmental lawyer that also works at the interface with human rights and Indigenous rights, it has to address the severity of the degradation and not just the impacts now, but for future generations. So I think ecocide is an important complement to existing environmental laws, and it sends a strong message to the community of nations and corporations, moreover.
Thank you. And Damien, some concluding remarks.
Yeah, thank you, Matthew. Look, for me, I think this is just such a fascinating and important conversation. And I'm so pleased that ADB, has been able to play a role to bring together some of these fantastic experts that we've heard from today. So, if we've done anything to at least begin a conversation with some of the people who have participated in this webinar, and also to sort of continue to sort of promote these kind of ideas, then I think, we've accomplished something today. So, this is really just a tremendous opportunity, fascinating idea for all of the international lawyers out there who are taking part tonight. I'm sure it's been sort of a fascinating conversation. So just from my perspective, I'll just thank the panelists and also the ADB team, who's sort of done all the work behind the scenes to put this together. So, thanks, Matt, and back to you.
Thank you very much, Damien. And again, thank you to all our panelists and participants. And the impetus came from one of the ADB vice president, and I happened to have tuned into the launch, which was quite an extraordinary, discussion on this new idea for ecocide. So it's not a new idea, but the new definition in some respects of what has been a crime that has been at least at the forefront of people's minds. Again, ecocide is both on a domestic level and an international level being recognised. And as I think it was Emma said, it's this repugnant and antithetical behaviour. I notice Michael de Vriend has mentioned in the chat that the Belgian Parliament has adopted by a strong majority a resolution by the ecological Groen parties aimed at recognising international crime of ecocide. This sets a good foundation to get more countries, if the European Union and the EEC can align. And obviously with the change of government in Germany, that might be also a potential. I think the discussions, though, about the role of international environmental law is also something that I find unique, but also fascinating. I've been an environmental lawyer now for 35 years, and I think we sometimes, as environmental lawyers, forget how rapid the transformation has been in terms of international environmental law. When I studied public international law at university, not as an exciting topic as it now is, in 1988 and 89, it was very much talking about the long process of development of customary law norms, but also the long process of developing treaties. And we look at how long it might have taken to develop UNCLOS, the law of the sea. And yet now we see how the Framework Convention on Climate Change and some of the issues arising from them, some of the other issues about the idea of an international environmental law for environmental impact assessment and what that might mean in terms of customary international law. The role of developing environmental courts and tribunals, which is something that the Asian Development Bank has worked on with national jurisdictions in Asia and the Pacific over the last 12 years. And that has led to this idea and the greater determination of environmental cases at domestic level. The extraordinary and outstanding work of the Environmental Defender's Office in Australia has brought a number of cases to the extent that the rule of law is often opposed by certain politicians, calling it lawfare, when it is in actual fact the exercise of due guaranteed rights under law and acted and interpreted by the courts in an appropriate legal way. And finally, of course, the groundbreaking and extraordinary work that Rizwana and the Bangladesh Environmental Law Association has done, the environmental law champions in the region, without whom environmental litigation would not advance. It's not just the lawyers, it's the plaintiff, it's our environmental and human rights defenders that are constantly under threat, constantly under threat of harm and danger and possibly death, people that need to be protected, lawyers who need to be protected. And so can I thank you all for your participation in this panel? Can I thank all of the commentators, our participants, for the extraordinary questions that have been given to us? Can I also say thank you also again to the ADB for the development of this Environmental Law Champions website. For some, it might even be good morning. Thank you all very much for your participation, and it's a great pleasure to have you here today.